Hello everyone, my name is Schielke. I am a partner at Gallant and Partners, and I'm in the litigation department. So today we're going to continue a segment on the New Jersey Consumer Fraud Act. The New Jersey Consumer Fraud Act is a statute that was passed in New Jersey in the 60s. The Consumer Fraud Act was intended to protect consumers against the sharp practices of vendors in different industries, including in connection with big life-changing purchases, like when you purchase a house or when you purchase a car, but it really applies to any consumer goods. And one of the benefits of the Consumer Fraud Act, or one of the reasons why it's considered as the strongest consumer protection act in the whole country, is because of the mandatory award of attorney's fees to a successful claimant and also treble damages, which means 3 times your actual provable damages. So if an attorney takes on a case for a consumer that has lost maybe even only a couple of $100 or a couple of $1,000, if the case doesn't settle and it has to go to trial and the jury or the judge finds that the Consumer Fraud Act was violated, then the attorney for the claimant, the consumer, could potentially recover attorney's fees for significantly more than the amount in dispute. So even if the client's damages was only $100, theoretically the attorney can go through a full-blown trial, all of the discovery, the whole case that may take years to complete, and then recover an award of attorney's fees payable by the defendant for $100,000 plus. Now, there is no proportionality requirement that the attorney's fees be commensurate or in an amount similar to or equal to the damages or the ascertainable loss that was sustained by the plaintiff or by the client. So this is intended to create a lot of incentive on the part of the defendants to settle the case early. They're looking at potential 3 times their damages and also attorney's fees. So they have a lot of motivation to try to negotiate a resolution in good faith. And so many times these consumer claims are settled with a demand letter sent at the very beginning of the case, where the consumer's attorney sends some written correspondence to the vendor or the potential defendant explaining why they violated the Consumer Fraud Act and also explaining the exposure to damages if the case does not settle. So many times cases will settle at very early stages in the case in response to a letter sent by the attorney because of the threat of attorney's fees and the threat of treble damages if the claim is successful. There are 3 ways in New Jersey to violate the Consumer Fraud Act. One is by an affirmative act, if the defendant tells a lie or takes some other affirmative action that constitutes an unconscionable commercial practice. Like in one case that I was involved with, a landlord wrote on a lease, "The property is not in a flood zone." And that was factually incorrect. Even though the landlord believed that what he said was true when he wrote that the property was not in a flood zone, it was in a flood zone, and he was wrong. Intent is not a factor. Normally, when you're trying to prove fraud, common law fraud in New Jersey requires that the defendant know that what they're saying is false, and that they do so with a subjective state of mind and an intention to deceive the person who they're speaking with. The Consumer Fraud Act reduces the burden on the plaintiff and eliminates some of the elements required for common law fraud. So it doesn't matter whether or not the landlord in that case knew or didn't know that the property was in a flood zone. The fact that he said that it was not in a flood zone, and it turns out that you can prove with records from the municipality that it was in a flood zone, that's all that the plaintiff needed to prove. And that was a violation of the Consumer Fraud Act that triggered the attorney's fees and the mandatory trebling of damages. And there's really at that point very little that the landlord can do to defend the claim based on liability. That's liability established right there. A false statement of fact constitutes an affirmative act and one of the ways to violate the Consumer Fraud Act. Another way to violate the Consumer Fraud Act would be a knowing omission. That's when the law imposes a duty on someone to do something. That could be implicated, for example, in the sale of real estate. If the seller of the real estate knows that the property had a problem with roaches and that the roaches hide during the day, so that when the prospective purchaser went there with his inspector, didn't see the roaches, but at nighttime they come out. And if that's something that the seller knows, or even the real estate agent, the broker for the seller, if that's something that they know, like some type of material defect with the property that would constitute a latent defect or something that is difficult to detect through an inspection or just normal due diligence, then that creates a burden on the part of the seller to disclose that. And if you don't disclose something that you're required by law to disclose, that would constitute a violation of the Consumer Fraud Act as a knowing omission, or the second category. Now that's a little harder to prove because it does require you to prove that the defendant knew and had purposefully decided to withhold that information. Again, that's something that can be proved, but it would require a little bit more evidence in order to establish a knowing omission. And then the third category of violations of the Consumer Fraud Act would be per se violations. These typically are violations of administrative regulations that are promulgated by the Department of Community Affairs. So the Department of Community Affairs would create what's called the New Jersey Administrative Code. And there are different sections of the New Jersey Administrative Code that are applicable to consumer transactions. For example, home improvement contracts. A home improvement contract is required by regulation to have a start date, an end date, to have a description of any materials that are included, to be signed by all parties, and there are other disclosures that are required by this regulation, including that the contract identify the license number or the registration number of the home improvement contractor, and that the price be set forth in the written contract, and any change orders must also be in writing. You have to also include the consumer's 3-day right to rescission or to cancel the contract up to 3 days after the contract is signed, giving prospective consumer the right to change their mind if they do so within 3 days of signing the contract. And they also, the contractor also has to provide in the contract the telephone number and contact information for the Department of Community Affairs. This way, if there is a grievance about the contract or the contractor or the process or the project, that the consumer knows who to contact. And any failure to comply with these and the other requirements set forth in the regulation constitutes a violation of the Consumer Fraud Act, and is actually considered a per se violation. Per se meaning you don't need to prove anything else. All you have to show is here's the contract and look what's missing. A missing item that's required under the regulations is a violation of the Consumer Fraud Act that could potentially trigger award of attorney's fees and then also treble damages for any ascertainable loss that the consumer suffers as a result of the violation. So maybe not every violation would result in a loss. If, for example, the contract is missing the required start date and end date, but was completed as agreed and started when agreed, then there wouldn't be any ascertainable loss resulting from that particular violation. But if there was no start date and no end date, and then part of the grievance of the consumer is that the home improvement contractor didn't start when they were supposed to start, and there were all of these delays, and then there was damages. Let's say that the consumer couldn't live in his house because the work wasn't done and had to rent a hotel, or incurred other damages resulting from the untimely performance of the home improvement contractor. Those would be considered ascertainable losses that resulted from the violation of the act, and then could be trebled. Trebled means to multiply by 3. So it is a punitive aspect of the Consumer Fraud Act to have this treble damages, but it wouldn't also bar other awards of punitive damages that are available pursuant to law. Now, I recently had a trial that implicated the Consumer Fraud Act, and after a complaint was filed, and then there was an answer, then there was discovery, and then post-discovery, there was some motion practice. At the end of the day, you have the trial. When both sides go to court, and they tell their story to the jury. This was a jury trial. And what the judge had to do was read to the jury instructions, they call them jury charges, about the Consumer Fraud Act, to let the jury know what the law is. So the jury is the judge of the facts. They decide what happened, they assess the credibility of the witness's testimony, the documents and other evidence, and they decide what happened. And then they have to apply the facts to the law. And the law is what the judge tells them the law is. The jury doesn't get to decide what the law is. That's decided by the legislature and by courts as they interpret the laws of New Jersey. And so the judge read on breach of the Consumer Fraud Act the following to the jury. Many of us have heard the Latin phrase caveat emptor, let the buyer beware. That statement allows little relief to a consumer. That statement does not reflect the law in the state of New Jersey. Here we have a more ethical approach to business dealings with one another. Therefore, each of us may rely on the representations made in a business transaction. This approach is reflected in a statute, the New Jersey Consumer Fraud Act. There are 3 possible bases for responsibility under the Act. Only one of them was implicated in my case, and that was the Affirmative Act. The Act, or the Consumer Fraud Act, makes any unconscionable commercial practice, deception, fraud, false pretense, false promise, or misrepresentation unlawful. These are considered affirmative acts. An affirmative act is something done voluntarily by a person. The act may be physical, but may also be any steps taken voluntarily by a person to advance a plan or design or to accomplish a purpose. Here, in my case, the plaintiff claimed that the defendants violated the Consumer Fraud Act by misrepresenting defendants' intention to sell a certain piece of residential real estate, a house, to the plaintiff at the party's agreed upon price, by misrepresenting the defendant's need for a cash loan to complete the project, and by misrepresenting the timeline for the delivery of the property to the plaintiff. Specifically, defendants allegedly used, by means of an affirmative act, an unconscionable commercial practice and or a misrepresentation in connection with obtaining a written agreement to sell the property, and also an amendment or a second contract for the same transaction, and then also a third agreement for an oral cash loan. So the facts of that case were very specific, and every case has unique facts, but the law would be the same for each case, and we would have to assess the facts in light of the law. So the following definitions apply to the New Jersey Consumer Fraud Act claims. And this, again, is what a judge will read to the jury at the end of the case. So it's important when you're meeting with an attorney at the very beginning of the case to understand what the jury instructions are, to understand what the finish line will look like and what you have to prove in order to cross that finish line. So you'd have to prove that there was an unconscionable commercial practice committed by the defendant in order to be a successful claimant under the Consumer Fraud Act. And an unconscionable commercial practice is an activity which is basically unfair or unjust, which materially departs from standards of good faith, honesty in fact, and fair dealing in the public marketplace. To be unconscionable, there must be factual dishonesty and a lack of fair dealing. So in my case, the judge read the jury instructions. There was 50-something pages of jury instructions that covered all different areas. It covered what the role of the jury is, the role of the judge, the role of the attorneys. It talked about assessing credibility. It talked about all of the plaintiff's claims. There was claims for breach of contract, breach of the covenant of good faith and fair dealing, consumer fraud, common law fraud, among other claims. So this is just part of the instructions that the jury was read. And the jury didn't receive a written copy of the instructions. They just sat there and listened to the judge state it verbally. And it's hard to absorb all of that information sitting in the jury box, especially when it's read. It took over an hour to read from the beginning to end of all of the instructions. So during the deliberations, and after the jury heard all of the evidence, heard all of the instructions, they were sent in a back room to go talk to one another and to decide how the case should be concluded, what the outcome would be, whether the plaintiff was successful or the defendant was successful, and they have to vote at the end of the day. And in a civil case, there are 6 jurors. Any decision has to be either unanimous, 6-0, or at least 5-1. So 5 out of the 6 jurors have to agree. So when they went into the back to deliberate, they came up with a question. They knocked on the door, they passed a note to the bailiff, the security officer in the court, who gave it to the judge, and one of the questions was, could you define unconscionable commercial practice? So the judge read back to them that same language that I just read to you, defining what an unconscionable commercial practice is. And after reading it to them, the jury went back and decided that there was a violation. So a deception is another term that the judge had to define to the jury in order for them to decide the case. And he read to them that a deception is conduct which is misleading to an average consumer to the extent that it is capable of and likely to mislead an average consumer. It does not matter that at a later time it could have been explained to a more knowledgeable and inquisitive consumer. And it does not matter whether the conduct actually misled the plaintiff. The fact that defendants may have acted in good faith is irrelevant. Just like in that example about the landlord who wrote in the lease, the property is not in a flood zone. Even if he in good faith believed it at the time, it doesn't matter. If it's factually incorrect, that constitutes a deception or a violation of the Consumer Fraud Act. And it is the capacity to mislead that is important. So fraud is a perversion of the truth, a misstatement or a falsehood communicated to another person, creating the possibility that that other person will be cheated. A false pretense is an untruth knowingly expressed by a wrongdoer. And a false promise is an untrue commitment or pledge communicated to another person to create the possibility that the other person will be misled. And a misrepresentation is an untrue statement about a fact which is important or significant to the sale or the relevant transaction and is communicated to another person to create the possibility that the other person will be misled. A misrepresentation is a statement made to deceive or mislead. A lot of the language is difficult to absorb. A lot of fancy words sometimes seem like it's jargon and legalese. And it's difficult sometimes for the jury to understand what the law is and how to apply it to the facts. But that's their job. And so they're given instructions. The instructions that I read to you were the instructions that the court provided to the jury, in that case, to help them understand what they had to decide. And then they were given what's called a verdict sheet. This is a number of questions about the different causes of action, trying to help guide the jury to their conclusion. Questions on consumer fraud. Did the defendant make a false representation of fact to the plaintiff? And then the jury had to answer yes, no, and then indicate that the vote. Was it 6-0 or 5-1? And for that question, they did find yes, that the defendant made a false representation of fact. The next question on consumer fraud was, did the defendants use an affirmative act of deception to commit an unconscionable commercial practice relating to the sale transaction for the property? The jury answered yes, 6-0. Next related question was, mark below and identify which of the defendants, in this case there were 3 defendants, a company, which was a limited liability company, that was the party to the contract, and then the 2 individual owners of the company. One very significant aspect of the Consumer Fraud Act is that there's a way to breach the limited liability protection of the corporate form. So the whole point of creating an LLC, a limited liability company, or a corporation, S corporation, C corporation, the different forms that are available in New Jersey for creating companies are intended to protect the owners, the individual proprietors, from liability for the acts of the company. And so normally, if the company is the party to the contract and there was fraud committed by or some other act, tort, or liability was committed by the seller or the company, then liability would be limited to that company, and you couldn't sue the individual owners of the company. But the Consumer Fraud Act and also common law fraud creates exceptions. so that if the owners of the company were the ones that participated in the fraud, that they were the ones that were acting on behalf of the company when they committed the Affirmative Act or committed the deception or the unconscionable commercial practice, then not only is the company responsible, but also the individuals. So this question, a judge asked the jury to mark yes below to identify which defendants used an Affirmative Act of deception to commit an unconscionable commercial practice. This was where the jury decided who has to pay. And here they decided the company and the two individual owners of the company were responsible and committed the act because they all participated in the underlying conduct, in the fraud, in the deception that caused the ascertainable loss to the plaintiff. And then the judge asked, what amount of damages did the plaintiff sustain as a result of the Affirmative Act and deception to commit an unconscionable commercial practice? And here the jury was directed to insert a dollar amount. So there was a dollar sign in a blank space, and they wrote in the number that was the ascertainable loss. And they were told in advance that whatever number they decided was going to be multiplied by 3. The jury doesn't do the arithmetic. They don't multiply by 3. They don't award 3 times the damages. They just put in the underlying amount of the ascertainable loss with the understanding that the judge will multiply that by 3. And they're told that to help guide their decision. I guess the legislature and the courts have decided that it would be unfair for the jury not to know the consequence of their findings, for them not to know that whatever number that they write in the blank will be multiplied by 3. So they know that, but they don't actually do the arithmetic. At the end of the day, the number that they wrote in was multiplied by 3, and then that gets entered into the judgment. When the judgment is entered, then it becomes enforceable. Now, in this particular case, once the jury verdict came back, the defendants threatened to file for bankruptcy. And one significant aspect of the Consumer Fraud Act, and all fraud really, is that those claims are not dischargeable in bankruptcy. If you have a judgment entered against you, or you have liabilities to your creditors, whether it's for a consumer matter or for a credit card or for any other transaction, if your debts are greater than your assets, then you may be eligible for protection from filing a bankruptcy. There are different bankruptcy chapters that may be applicable depending on the circumstances, but for whatever chapter or whatever relief that you're looking for from the bankruptcy court, whether it's a payment plan to pay your debts over time or a discharge if you want a clean slate, one thing to keep in mind is that certain debts are not dischargeable. Types of debts that are not dischargeable would be fraud, whether consumer fraud or common law fraud. In this case, the jury found that the defendants were liable for both consumer fraud and for common law fraud. Those debts are not dischargeable. So although they were threatening to file for bankruptcy, and that would trigger an automatic stay and cause some delay, it wouldn't, at the end of the day, deprive the plaintiff of the right to collect the amount that the jury awarded, because fraud is not dischargeable for public policy reasons. The benefit or the purpose of bankruptcy is to allow people who have more debt than they can pay relief so that they can have a fresh start. But it doesn't allow people who commit fraud to avoid their obligations because of the malice that's required in order to establish fraud. There's some consequences to that type of misconduct to discourage people from committing fraud.